Hi, I'm Martha Karua, was a member of parliament for Gishogo constituency for 20 consecutive years. I was in the 13th parliament, the parliament that ushered in the 2010 constitution. I'm proud to have been one of those who stood in the committee of constitutional review process, which later morphed into the Committee of Implementation of the Constitution after the 2010 referendum that ushered in the Constitution. So literally, was happy to be one of the midwives of the Constitution. My journey with the Constitution formally started in 1998 during the Inter-Party Parliamentary Group, IPPG meetings, when we got KANU to agree to start the formal journey, and they presented a bill, the Constitution of Kenya Review Act, which we later worked on in 1998. And I'm happy to be here on PolitiKali Konekted to tell you all about my journey with the 2010 Constitution. They saw these powerful women. We shall fight for our rights. It was written in the old Constitution, sex, not gender. No reform, no election. We should never be gagged. Kibaki, the new president, gets a stroke. Kibaki sacked all the ministers who had campaigned no. Beginning with Raila Odinga, that's how we as a country sold seats of post-election violence. Long live 2010 Constitution. Viva Katiba ya Kenya. For those who may not know, I started my career as a magistrate. That was way back in 1981, July. I remained a magistrate starting in Nakuru, ending up in various stations in Nairobi. I was in charge of Makadara Law Courts once. I was in charge of Kibera Law Courts. And that's where I exited from the judiciary to start my legal practice way back in 1987. Once I started my legal practice, I was thrust into the middle of activism. It was a time when the KANU regime was literally stepping on the throats of Kenyans, when the democratic space was shrinking. And I, along with other young lawyers, for your information, I was a young lawyer then, barely 30. We started activism, and we started demanding of the leadership of the Law Society of that day to delink itself from the KANU regime and to stand up for the rights of Kenyans as demanded by Section 4 of the Law Society of Kenya Act. And when they did not, and we thought they were causing up with the government, we started drawing requisitioning for a general meeting of all lawyers to sanction the leadership. I used to author the requisition and then sign it, get others to sign it, because there's no way you're going to author a document and give it to others unsigned. And all we required were 15 lawyers. Then the total number of lawyers was just about 2,000, not like the close to 30,000 there is today. So I would get 15 people, and we would send a notice to the Law Society leadership and tell them to convene a general meeting. The law said, and I know it says even today, that if they do not convene a general meeting, then you, the requisitionists, can actually convene one. So they would fail to convene the meeting, and we would convene the meeting. Most Law Society meetings were then held at the Intercontinental Hotel, which is now dormant. And from there, anytime we requisitioned a meeting, police would be sent to condone the hotel so that the meeting did not take place. That's how my activism was born. And I say this was a time of necessity. It was a time just like today. We started run-ins with the government of the day because they were curtailing our freedoms. We were entitled to meet under the Law Society of Kenya Act, under the Constitution of Kenya, which still gave us the freedom to assemble. So the way you are seeing police stopping demonstrations, even when the Constitution of Kenya 2010 in black and white says you have a right to meet, this did not start today. The only difference between that time and today, the police would clamp down on us, and even when we went to court, the court would not stand up for us. Today we have bold judges and magistrates. Not all of them, but we have bold magistrates, judges of all the courts who can stand up for the people of Kenya and rule in accordance with the Constitution of Kenya. In my time, Koigi wa Wamwere and his co-accused were charged with treason. But if you look at the basis and the evidence the government had, it was just a pamphlet they wrote which had the words, "We shall fight for our rights." So it's like they took the word fight to be literal, like a fight taking arms. They were charged with treason. It's not a case they could have proved. Clearly, it was lawfare, politically trumped up charges. You see them today. Recently, Bob Jage was charged with treason. I salute the court that dismissed the charges because the charge did not disclose any offense. It is the same thing Besigye is being tried for in Uganda. It is the same lawfare in Tanzania, which Tundu Lissu is being charged for merely saying no reforms, no elections. So you can see the world became more open. It's again beginning to close in. It's up to you and me to defend the Constitution of Kenya 2010 for us not to get there again. Allow me to take you back to activism. My activism as a member of the Law Society of Kenya, as a young member then, got me to be a household name in Kenya. So by 1992, when the country reverted from one-party status to multi-party democracy, I decided to run for parliament. And I'm running against the background as an activist with a name in the country. By then, I was going by the name of Martha Joka. Joka is the father of my children. He's now late. So I decide to run, and I am elected the member for Gishogo constituency. And we come to parliament. KANU has again won the elections. Won because the opposition, which had a majority in Kenya, just like today, split into three big groups. More than three, but split into three. Mwai Kibaki's DP, I was in that party, Matiba's Ford Asili, and Jaramogi Oginga Odinga, the father of Raila, in Ford, Kenya. Look at that. Ford splits into Ford Kenya of Odinga and Ford Asili of Matiba. And Kibaki comes in and forms DP. The votes those three parties got amounted to 67% of the vote, obviously a majority. But Moi sails through with 33%. I am saying that because I want you to know, those of you who are not adults then, that you must reign on in us, on the opposition to which I belong, that we must stick together so that we do not frustrate Kenya's journey to a new Kenya, to a better governed Kenya. That yes, today, all polls are showing the government of the day has lost favor. But should we split and not approach this election united, we can give victory to today's oppressor. You have a role. You have to keep telling us to stick together, and you must be able to select one among us to carry the one-term flag. It is up to you. You can't put the pressure on us. So yes, we lose the election to KANU, and because of gerrymandering of the constituencies, yani the delimitation of constituencies in an unfair manner, 67% did not have many seats in parliament. KANU with 33 had a majority in parliament. It means that equality of the vote was still elusive. It means the KANU's 33 has more members of parliament than the 67 of the opposition. In parliament, therefore, the voting is skewed. So KANU would sort of win all the time. Our voices were loud as the opposition, but we hardly could pass anything. We tried. There was a civil society movement which had some members of parliament, and the call was towards the 1997 general elections. No reforms, no election. The same thing Tundu Lissu has been in Tanzania, has been charged with treason charges. We were in Kenya saying no reform, no elections. We were not charged with treason. Same thing, same laws, different outcomes. So yes, KANU was bad, but KANU was still giving us more space. The leading civil society on the no reform, no election call was the National, I was said convention, I can't remember, but the abbreviation was NCEC, led by then law lecturer Kivutha Kibwana. And it was operating from Ufungamano. And members of parliament, political party leadership had gone to Ufungamano. My leader, Mwai Kibaki, had gone to Ufungamano. Paul Mwita was at Ufungamano. Paul Mwita was then of Jaramogi's Ford, Kenya. Most leaders were in Ufungamano. I refused to go to Ufungamano. Not that I did not agree with them, but I felt being an elected member, having the forum of parliament, my question was, am I utilizing my forum properly as an elected leader? So we got together with our rivals in KANU, George Anyona, then of the opposition party KNC. I represented DP. There was Jilo Falana of KANU. I won't be able to mention everybody, but there were members of parliament from different sides. We decided we needed to use the forum of parliament. Otherwise, we were being rendered useless by the calls outside when we could not do anything. So when we started that initiative, KANU was very happy. It's like we had given not just parliament, but the country a lifeline, because there were violent confrontations between the NCC group from Ufungamano and police, sometimes in the streets when people are demonstrating, and it was getting ugly. So suddenly we found we not only had live coverage from KBC, which was the only medium of communication then, and we were getting both TV and radio, and Parliament, instructed by Moi, gave us a secretariat. They suddenly came to cover our meetings. So we formed 3 committees, the Constitutional Committee and the Legal Reforms Committee. I can't remember the third committee what it was, but I was in the Constitutional Committee. which had 20 people. We were only 6 female members of parliament. So obviously, I'm alone in the legal committee. Phoebe as CEO, and I can't remember who else were in the other, the legal committee, etc. So this is the IPPG. And we instituted both constitutional and legal reforms. Some of the constitutional reforms we instituted: we abolished discrimination on basis of gender. It was written in the old constitution, sex, not gender. The word sex was being used instead of gender. Okay. So we abolished discrimination on basis of sex. On the 12 nominated seats of parliament, which are still present even in today's constitution, we passed a constitutional amendment to decree that those 12 seats will be shared. The nominees will be both men and women, 6-6, and that they'll also be shared between political parties in proportion to their numbers in parliament. Previously, KANU used to nominate alone. Even when we had 67%, KANU nominated alone. Then we had another clause saying for the local authorities, remember those are the days of councillors, this section we will apply similarly. They didn't have 12 nominated seats, but they had nominated members in each county assembly. The word used was that it was a Latin word that it will be used mutatis mutandis. It will be the same as the members of parliament. What these 2 or 3 simple amendments did was to ensure that women were nominated in all county councils throughout the republic, that even though they did not follow the rule of half-half, there wasn't any party in Kenya where there wasn't now a woman in the county assembly, in the county council. So this was a revolution, a gender revolution. And this paved the way in 1998 when we formed the Inter-Parties Parliamentary Committee, IPPC, to steer the constitutional review process. We have now been re-elected. We are in 1998. We then, when writing the Kenya Constitution of Kenya Review Act 1998, we wrote a clause that in all organs of review, 1/3 of its membership will be women. This is where we start the gender quotas, without calling them that. Something that doesn't look like it in IPPG, IPPC has now decreed. And I'm proud to say, when we formed the Inter-Parties Parliamentary Committee, a big meeting was called was it in Safari Park, or I can't remember the exact venue, but firstly it was in Bomas, then in Safari Park, where a committee was selected for drafting the Constitution of Kenya Review Act 1998. That conference had both parliamentarians, civil society, political parties, it had everybody. It was like the Kenya We Want Forum. And I and Professor Wanjiku Kabira were appointed or elected as the joint secretaries of the 15-member committee. It was called Sulumeti Committee. Bishop Sulumeti is late, God bless his soul, because Sulumeti was its chairman. So the Sulumeti Committee had of 15 had 5 women. And 2 of those women were the joint secretaries. That's me and Professor Wanjiku Kabira. And that is how the review process started. So fast forward. The organs of review were 3. The commission, which was going to have both men and women. Then there was the county committees, which would have women, and then the national convention or national conference, which would have people coming from all the county. There were not counties, there were the county council or districts, if you like. And because already we have said organs of review must have 1/3 women, it means the architecture of the review has gender quotas in it. And that is what has ended up in our 2010 constitution. The only place where there were no gender quotas is Parliament. Because Parliament, by that time, we are in 1998, 1997 December, only 4 of us of the 6 were re-elected. But remember, the law now says that of the 12 nominated seats, 6 will belong to women. KANU goes on its own way again, and instead of nominating sufficient women, 7 men are nominated because Moi wins a second time. They nominate 7 because of the disunity among opposition. They nominate 7 men and only 5 women are nominated. We took a case to court, but the case was never decided until the term of Parliament ended, and by then 202 Kibaki had come in.